of abusing 16 of her grandchildren by allowing them to live in conditions in a home in Vinton County, Ohio, that the sheriff said weren't fit for livestock. The children...
On June 30th, 2026, law enforcement in Vinton County, Ohio, entered a home on Omar Street. The sheriff would later say the conditions inside were not fit for livestock. 16 children were removed, 4 adults were arrested, and within weeks, a motion landed on the docket that stopped the narrative cold. It was filed by the grandmother, Christina Ciders, through her public defender, and it argued something simple: the state has charged her with abusing all 16 grandchildren, causing each one serious physical harm. Then the motion asked, where is the proof? Think of a single light bulb hanging in a root cellar still burning while the floor around it has collapsed. The bulb works. The foundation didn't. The evidence isn't missing. It was never supplied.
Law enforcement arrived at defendant's home with the purpose of serving another member of defendant's household with an arrest warrant for unrelated misdemeanor charges. Nonetheless, defendant was detained and arrested outside her home. After providing a statement and cooperating with law enforcement during an interrogation at the Vinton County Sheriff's Office without counsel present, defendant was ultimately charged by complaint with one.
The motion filed by attorney Cander Roberts opens not with an emotional appeal but with a timeline. Deputies came to serve an unrelated misdemeanor warrant on another household member. Christina Ciders was outside. She cooperated. She gave a statement. She was interrogated for hours at the Vinton County Sheriff's Office without counsel present. Only after that did she face 16 second-degree felony counts of child endangering, 1 for each grandchild living under the roof she rented. The narrative that emerged in the press was one of monstrous neglect. The legal filing tells a quieter story. A 66-year-old woman with no criminal record sat in a room, answered questions, and then was charged. She has remained incarcerated ever since.
Was, of course, supposed to ensure that a person charged with a crime shows up for court. It's not supposed to be a punishment. Roberts cited case law, writing, if a court orders financial conditions of release, those financial conditions shall be related to public safety, the defendant's risk of non-appearance in court, the seriousness of the offense, and the previous criminal record of the defendant. Roberts continued, the court must consider the defendant's ability to pay.
The bail motion then pivots to a constitutional argument. Roberts quotes case law directly. Bail is not punishment. It ensures appearance. Financial conditions must relate to public safety, flight risk, offense seriousness, and criminal history. Then the key sentence: the court must consider the defendant's ability to pay. Setting a high bond to keep an accused person locked up before trial, Roberts writes, is both statutorily and constitutionally unlawful. This is not rhetoric, it is black-letter law.
Christina Ciders' lawyer also questions the weight of the evidence against her. The state has charged defendant with endangering children, which would require evidence that on or about June 30th, 2026, defendant did abuse each of her 16 grandchildren, and that she caused serious physical harm to every one of the children. To date, the defense has received scant evidence suggesting defendant committed any of the alleged offenses. The weight of the evidence against defendant is minimal. In fact, to date, there is no evidence that has been provided which would support the finding that defendant committed any acts of abuse, let alone that any of the children suffered serious physical harm because of abuse by defendant.
And then the filing turns toward the heart of the case. To charge child endangering resulting in serious physical harm, the state must possess evidence that the defendant abused each child. Roberts states directly, to date, the defense has received scant evidence suggesting the defendant committed any of the alleged offenses. The weight of the evidence is minimal. There is no evidence provided that any child suffered serious physical harm because of abuse by the defendant. None. What the state has presented, the motion argues, is only that she resided in the home and that the conditions were unsanitary enough to justify removing the children from their parents. A dirty house is not the same crime as inflicting harm. The motion draws that line in ink. The paperwork already knew.
Conditions of the home were unsanitary to the extent that the removal of the children from the custody of their parents was deemed necessary by authorities. Christina Ciders' attorney says she has no prior criminal record, and while she can't return to the home on Omar Street, she has a place to stay if she's granted bail. Roberts wrote, defendant has strong family support. In fact, in release, defendant will reside with close family members who are capable and available to assist in ensuring defendant's appearance at future court proceedings and defendant's compliance with any conditions of pretrial release imposed by this court. Defendant's financial resources are limited as demonstrated by her indigent status. As such, she has no resources or access to means which would make her a significant risk.
The defense then walks through the factors that typically justify pretrial detention and eliminates them one by one. Christina Ciders has no criminal record. She cannot return to the Omar Street home, but she has a place to stay with close family willing to ensure her court appearances. Her finances are limited, documented by her indigent status. She has lived in southeastern Ohio her entire life. She has no connections outside the area, no passport, no resources to flee. She is not a danger to the public. She is not a flight risk.
Family or other connections outside of the area. Defendant requires medical treatment related to her mental condition and many documented medical diagnoses, all of which can be addressed while defendant is not incarcerated in jail. Roberts continued, writing, none of the statutory or constitutional.
The motion adds another layer: medical necessity. Christina Ciders requires treatment for documented diagnoses that can be managed outside a jail cell. Roberts concludes that none of the statutory factors weigh in the state's favor. Each and every factor weighs heavily in the defendant's favor. Then she drops a procedural observation that lands like a footnote with a blade. Each defendant waived the right to a preliminary hearing where prosecutors would have been forced to show probable cause. That hearing never happened.
Asking for her client to be released on bail, she also wants her competency to stand trial evaluated. Attorneys for Gary Jr. and Gary Sr. have also made that request. Roberts wrote, defendant, by and through counsel and pursuant to a revised code, hereby raises the issue of her competence to stand trial. Counsel has reason to believe that defendant is unable to fully comprehend the proceedings in this court and is unable to assist counsel in the preparation and defense of this case. Defendant moves this court to order that defendant undergo a competency evaluation to determine.
The bail argument is only half the motion. The second half goes deeper. Roberts raises the issue of Christina Ciders' competence to stand trial. Counsel has reason to believe the defendant cannot fully comprehend the proceedings and cannot assist in preparing her own defense. The motion asks the court to order a competency evaluation and set a hearing once the report arrives. This is the third defendant among the four charged to request such an evaluation. The husband, Gary Ciders Sr., and the son, Gary Jr., have already made the same request.
No, not at all. I think just by the nature of the offense itself, what's publicly been disclosed, you have to even ask yourself, what are these people doing? What are they thinking?
When asked whether 3 competency requests in a single family case is unusual, former Franklin County prosecutor Ron O'Brien answered plainly not at all. The nature of the charges themselves, he said, forces the question, how did this happen? What were these people thinking?
Did this happen? 16 children, or actually 18 children born over a period of 15 years, some of them twins, but wondering what's going on there. And so, as many people will ask themselves, is there something wrong with them? And so I think that itself causes you to think that maybe there should be a preliminary psychological exam of the defendants.
16 children, actually 18 births, some twins, over a period of 15 years. The raw numbers make people ask whether something deeper is broken. That instinct, O'Brien argued, is exactly why a psychological exam is not a delay tactic but a necessary inquiry. The legal standard for incompetence is not whether a defendant is unwell. It is whether she understands the nature of the charges and can assist her lawyer. That second question, the ability to assist, is more often the basis for a finding of incompetence.
We've seen that in a number of cases over the years where somebody is deemed incompetent, then they are sent to some type of institution and they work on them by whatever means that is to get them to a level where they can assist in their own defense.
I think that's exactly.
If the evaluation concludes Christina Ciders is incompetent, that finding is not permanent. Competency can be restored through treatment. Defendants across the country are routinely sent to state institutions, stabilized, and returned to face the charges. It is a pause, not a dismissal.
I think you're correct that the trial judge will order the competency exam. Sometimes the defense attorney offers more to the judge as a basis to order the competency exam, such as when I visited the offender in the jail. They couldn't tell me about the offense, or they talked about other things, or they couldn't remember things. Kind of the questions that the psychologist is by statute required to look into. But in this case, it was a.
O'Brien predicted the trial judge will grant the evaluation request. Even a bare bones motion that offers no detailed reasons, simply a statement that counsel has questions, is typically enough to trigger the exam. The psychologist will ask about the offense, the defendant's relationship with her lawyer, and her understanding of what is happening. Standardized tests for reasoning, communication, and comprehension will follow. The first examiner's report is the most consequential. Both sides can request a second opinion. The court can appoint a tiebreaker, but the first one sets the trajectory.
Right now, Christina, Gary Jr., and Elizabeth, they're all being held on a $300,000 bond. We know they can't post this. We get it. We know. So she wants her client released on bail. She said she has supportive family members who would make sure she gets to court appearances, etc. How likely is this to be granted, a reduction in bail? Because we don't even have a grand jury indictment right now.
That's correct.
Then there is the bond itself. Christina Ciders, Gary Jr., and Elizabeth are each held on $300,000. The defense does not dispute that they cannot pay it. The question is whether the amount is reasonable or whether it functions as detention by another name. The case has not yet gone to a grand jury. No indictment exists.
What the grand jury's going to do? So
there's no indictment, and actually she's not. She's now going to be examined for competency, and generally the psychologist would want the easy availability to the defendant, which is occurs when they're in custody. And so I think that the chances of a reduction are probably 50-50. And when I say that, it may not be a reduction that causes her to be able to post that bond, because
O'Brien assessed the likelihood of a reduction at roughly 50%. A judge wanting to insulate the decision from a habeas corpus challenge might reduce the bond from $300,000 to $100,000. A number still far beyond the defendant's means, but a documented acknowledgement that the original amount was excessive. The 2022 amendment to the Ohio Constitution now permits judges to weigh public safety and risk of further harm to victims, not just flight risk. That shifts the calculus.
there are some interesting little nuggets that she dropped, Cander Roberts dropped in this motion to reduce bail. She's essentially saying, and we can see where their defense is going to be, what their defense is going to be in this case. But she's essentially saying, look, my client was paying the rent at this place. They were staying there. These are their kids. You know, they are her grandchildren. However, it was still her home. So what responsibility do you still have if you have a family members with 16 kids living in your home, and they go in and they find feces and trash all over the floor, and it's disgusting, as the prosecutors and the sheriff's office have said? What responsibility do you?
And yet, buried in the motion is a preview of the defense strategy. Roberts acknowledges her client paid the rent. The grandchildren lived under her roof, but the motion draws a distinction between presence and perpetration. The prosecution has described floors covered in feces and trash. The defense does not deny the filth, it denies causation. It asks, what legal responsibility does a 66-year-old grandmother carry when the children's own parents live in the same home? Is being the leaseholder the same as being the abuser? The paperwork already knew.
That question is, I think, certainly grandma has that kind of responsibility, but is it a legal responsibility? If you fail to meet it, are you subject to prosecution for endangering children? And at least, I think, because of the relationship, say she was just a landlord and was letting friends live there for several hundred a month, it might be a different situation. But since she's a grandmother of the children, I think that she would meet that minimal responsibility of needing to do something in the face of what has been described as very horrific neglect at the premises.
The Vinton.
O'Brien weighed the question carefully. If Christina Ciders were merely a landlord renting to friends, the legal duty might be different. But because she is the grandmother, she likely meets the minimal threshold of responsibility. That does not answer the evidentiary question. It merely defines the legal perimeter. Meanwhile, Vinton County Children's Services has already signaled its intention. The prosecutor informed county commissioners that the state will seek permanent custody of all 16 children. That administrative proceeding runs parallel to the criminal case and carries its own standard of proof.
They would have to have a hearing before the juvenile probate judge there in Vinton County. They would have to file an abuse, neglect, dependency kind of charge, which is a separate kind of administrative proceeding in front of the juvenile court judge to make that determination whether the children are at risk, that's the allegation, and whether the custody of the children should not be with these parents or grandparents who had such neglectful conduct over a period of time. So it tells you that they think they have a strong case, number one, and it also tells you that they're willing to go forward.
The custody case will unfold in juvenile court before a different judge under a different burden. It will ask not whether Christina Ciders committed a felony, but whether the children can safely return to any member of this family. The fact that the state filed that intention early suggests confidence in its case. It also means the children will likely never go home regardless of what happens to the grandmother in criminal court.
People shared addresses in Gallia County. So they were living together at a house on Honeysuckle in Gallia County when the truancy action was filed. So these people have been living together for a really long time.
Right, and you would think also with regard to that issue that a grandparent would understand that it's in the child's interest and required by law that they attend school when they reach a certain age, and most of the children, or at least more than half of them, are over that mandatory minimum age. And as we talked about last week, they in fact had truancy charges filed on them that never went forward because they couldn't get service. So either they left that place and didn't leave a forwarding location in Gallia County, or the sheriff's office or children's services down there, or the truancy officer. Each school district by statute has the ability and does appoint what they call a
One additional thread runs beneath the surface: truancy. The family previously shared an address on Honeysuckle Road in Gallia County. At some point, school officials filed truancy charges. Those charges went nowhere because authorities could not serve the family. They had already moved. The system knocked. Nobody answered. Then the family relocated to Vinton County, where the children continued not attending school. This detail transforms the timeline. It means multiple agencies across multiple counties had contact points with this household long before the raid. So the question hovering over this case becomes unavoidable. What if someone had asked the right question on Honeysuckle Road before it all migrated to Omar Street?
As of now, all three defendants, Christina, Gary Jr., and Elizabeth, remain in jail on that $300,000 bond. Prosecutors have not responded to these motions filed by Elizabeth's attorney and Christina's attorney to modify their bail. So when they do,
as of now, 3 defendants remain in jail on the $300,000 bond. The prosecution has filed no public response to either motion to modify bail. The sealed search warrant affidavit, the document that would reveal what investigators told the judge they expected to find, is being challenged all the way up to the Ohio Supreme Court. The piece of paper that could explain what crime the state was searching for has not been unsealed. Nobody asked. Nobody answered. It was signed, then forgotten. The paperwork already knew.
prosecutors have not responded to these motions filed by Elizabeth's attorney and Christina's attorney to modify their bail. So when they do, we'll let you know what they say. You can read all of the records related to the Ciders case. We have the entire case file on our app, Law and Crime Plus. Check it out. And that's it for this episode of Crime Fix.
The entire case file, including the motions discussed, is available on Law and Crime Plus. The document you need to read is the motion to modify bail filed by attorney Cander Roberts in the Vinton County Court of Common Pleas. It contains the precise language quoted throughout this analysis. Read it. Then answer one question in the comments. If the state had evidence of serious physical harm to 16 children, why hasn't it shown any of it yet? Not to the defense. Not to a judge at a preliminary hearing. Not to a grand jury. We'll be back.